Crown on the application of Association of Independent Meat Suppliers and another, Appellants, and Food Standards Agency, Respondent.
Lord Sales will hand down the judgment.
This case is about the system to ensure that meat products are safe for human consumption. The relevant legal regime is set out primarily in certain EU regulations. The case arose at a time when the transitional arrangements in relation to Brexit provided for references to be made to the Court of Justice of the European Union. The Supreme Court made a reference to the Court of Justice in relation to questions of EU law under the regulations. The Court of Justice has delivered a judgment answering those questions, and the Supreme Court now determines the appeal in the light of those answers. The appeal concerns a bull which was purchased at market by one of the appellants, the Cleveland Meat Company, or CMC, which operates a slaughterhouse. CMC is supported in this appeal by a trade association, the Association of Independent Meat Suppliers. The bull was slaughtered and the carcass was inspected by the official veterinarian on behalf of the Food Standards Agency, or FSA. He detected certain lesions which caused him to think the bull was diseased, and so he designated the carcass as unfit for human consumption. CMC disputed the official vet's opinion. Since there was a dispute, CMC maintained that the official vet was required to take action by seizing the carcass using a power contained in Section 9 of the Food Safety Act 1990 and taking it before a justice of the peace to determine whether it should be condemned. CMC said that it was for the justice of the peace to decide, on the basis of expert evidence on each side, whether the carcass was fit for human consumption or not. And under the Section 9 procedure, he could order compensation to be paid if he decided that it had been fit for consumption after all. Against this, the FSA submitted that there was no obligation on it to use the Section 9 procedure because there were other methods by which it could ensure that the carcass did not enter the food supply chain. Since the official vet had not certified the carcass as fit for food, CMC was prevented by law from selling it for food. Instead, the official vet served a notice on CMC requiring it to dispose of the carcass. CMC and the association brought judicial review proceedings to challenge the FSA's assertion that it was not required to use the Section 9 procedure. In the alternative, they claimed that it was incumbent on the United Kingdom to provide a method of challenging the official vet's decisions. The judicial review claim failed at first instance and in the Court of Appeal. CMC and the association have appealed to the Supreme Court. The FSA's case is that UK law already provides a means for challenging a decision of the official vet regarding whether meat is fit for human consumption, namely by way of judicial review proceedings against him. In those proceedings, as in all judicial reviews, the court would check that the official vet had acted in accordance with the law, had not been irrational, and had had a sufficient evidential basis for his decision. Unlike in proceedings under Section 9, the court would not substitute its own judgment on the merits of whether the meat was fit for consumption for that of the official vet. The FSA submitted that this more limited degree of judicial control is all that is required under the EU regulations. The Supreme Court asked two questions of the Court of Justice of the EU. First, was the Section 9 procedure compatible with the food safety regime laid down by EU law? And second, if EU law requires that there be an appeal procedure to challenge an official vet's decision, what degree of judicial control is necessary to comply with that requirement? The Court of Justice held that EU law does require there to be an appeal procedure. However, on the first question, it held that the Section 9 procedure was not compatible with EU law. It was not a procedure apt to meet the requirements of EU law. It was not appropriate to allow the judgment of the official vet to be replaced by the judgment of a non-specialist, like a justice of the peace. Also, the Section 9 procedure did not allow a party such as CMC to bring a legal action of its own initiative, and, moreover, it did not authorise a justice of the peace to annul or lift the effects of the official vet's decision. On the second question, the Court of Justice held that a challenge on conventional judicial review grounds was appropriate. A decision regarding the safety of meat for consumption required technical knowledge and expertise and was directed to ensuring the highest standards of food safety. When assessing the degree of judicial control which was required, it was necessary to take into account the purpose of the decision taken by the official vet and to ensure that its effectiveness was not undermined. It is relevant that there are procedural safeguards, including a requirement that the official vet explain his reasons, which assist a party such as CMC to challenge those reasons in judicial review proceedings. In this area of applied expertise, therefore, judicial review of an official vet's decision on conventional public law grounds provided the slaughterhouse, like CMC, with appropriate, effective judicial protection. In the light of these answers by the Court of Justice, the Supreme Court is able to determine the appeal. It is clear that there is no foundation for CMC's contention that the FSA was required to use the Section 9 procedure, since that procedure is not compatible with the relevant EU regulations. Nor is there any basis for the alternative complaint that the United Kingdom has failed to provide an appropriate means to challenge decisions taken by an official vet, since ordinary judicial review is available and is appropriate for that purpose.
Thank you. Court is now adjourned.